viewers, Namaskar. I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on new criminal laws. This is the second lecture of the second part of that lecture series. In the earlier lecture, we talked about how IPC has changed from Indian Penal Code to Bhartiya Nyaya Sanhita. Now that was regarding the substantive law on crimes in India. In that lecture, we also talked about the main types of criminal laws, which are the substantive law and the procedural law. So while the substantive law lays down the substance of crime in the sense what constitutes criminal behavior, what entitles you to exemption from criminal liability, the procedural law lays down how a person accused of a crime is to be apprehended, tried and punished before the law. Now, in the previous lecture, we talked about how the substantive law has undergone change. Now, in this lecture, we will be talking about the changes that have been brought about in the procedural law. So, from CRPC 1973 to Bhartiya Nagarik Suraksha Sanhita 2023, what is the objective behind overhaul of the law? So, first we will try to decode the title. See, the law earlier was Criminal Procedure Code. Now, what is this law? The new law talking about? Bhartiya Nagarik Suraksha Sanhita. So, the objective of this law is protection of our people, and if anybody dares to disturb the peace and calm of the society, then such a person is to be apprehended and tried. So, when we are talking about protection of our people, it is not only the victims who are to be protected or the potential victims that are to be protected. We are also talking about protection of those innocents who might be wrongly accused or wrongly convicted of a crime. So, all that has to be taken care of. So, when the law was to be amended, the main focus of our lawmakers was first to ensure fast and efficient justice delivery. See viewers, justice delayed is justice denied. We all know that. But at the same time, we have to be mindful of the fact that justice hurried is justice buried. So, what is required is to strike a balance between the two. So, we need to ensure a fast justice delivery system without compromising on the rights of either the accused or the victim. So, we need to strike a balance between fast justice delivery and fairness of justice. So, with this objective in mind, there have been a vast change in the new procedures that have been laid down for trial of offenders in the new law. Secondly, the objective is to release under trials on personal bond. See, we have seen that people, they have been languishing in prisons for a long time, sometimes even beyond the maximum sentence for which they could have been sentenced had they been adjudged guilty by a court of competent jurisdiction. So, in order to put a check on this, now the law has made express provisions for release of under trials who have spent half of the maximum prescribed sentence in custody. Now they have to be released. Another objective is to reduce complexity by streamlining criminal procedures. See, people, they are so scared of going to the courts. People are so scared of approaching the police. They are scared that they will be shunted from one police station to the other police station, that this is beyond our jurisdiction, or we will first conduct a preliminary inquiry and then we'll decide whether we have to register an FIR. Sometimes we see that there are so many hassles during trials and unnecessarily elongated trials. So, we need to reduce those complexity of procedures by streamlining the entire system, and towards that end we have seen that the new procedural code, which is the Bhartiya Nagarik Suraksha Sanhita, has done an excellent job towards this end, and it will be more clear to all of you as we go further in the series. In the coming lectures, we will be talking about all those in detail. The other objective is to reduce pendency. How can we do that? When we prescribed timelines. Now there is a prescribed timeline. Investigation has to be necessarily completed within this period. The trial has to be completed within so much of time. So for all the procedures, the prescribed timelines have been set and they have to be strictly adhered to. Unless of course there is some exceptional circumstances, in such cases maybe a concession could be made. Otherwise we would all have to strictly adhere to the prescribed timelines, because the objective is to cut down on the pendency of criminal cases. We also need to improve rate of conviction. Now how will that happen? Only when there is a full proof investigation. It is because of shoddy investigations that most of the time the accused, they are able to escape, and once the accused are out, once those who were actually guilty, and when they cannot be convicted, why are accused persons not convicted? Once, because of shoddy investigations. Second, because the entire criminal justice system leans in favor of the accused person. See, what does our criminal law say? It says, let 99 guilty men go free, one innocent should not be punished. And that is the reason why the entire burden of proof, it rests on the prosecution, and rightly so. Because see, when we talk about the balance, on one side is one person who is an offender, at the other side is the entire state. Police, prosecution, judiciary. So in order to strike a balance, the rule is that the entire burden is on the prosecution, and the prosecution has to prove the guilt of the accused person beyond reasonable doubt. But what happens in such cases where the investigation does not carry on properly, and the reasons could be multiple. Sometimes we are understaffed, sometimes there are lack of resources, sometimes there are lack of facilities, due to which our investigations suffer, and due to which what happens, unless and until the prosecution is able to discharge the burden of proof beyond reasonable doubt, and if there is even a single iota of doubt in the minds of the courts, the benefit of doubt, it always goes to the accused person. And in such cases, such guilty people who could be a threat to our people, to our other ordinary law abiding citizens, such people, they get an opportunity to roam free. And that is why we need full proof procedures. We need an improved investigation. We need the prosecution to monitor all that, so that what happens, the conviction rate, it can improve. And that is, towards this end, a lot of provisions, they have been introduced in the new procedural law. Now coming to the appropriate usage of technology. What the new law says, that all trials, inquiries and proceedings, they should be conducted electronically. Now this would all help us a lot in cutting down times. See, sometimes in case of proclaimed offenders who are evading trial, we are not able to get them in front of the court. Sometimes they flee to other jurisdictions. We are not able to get them back to India. Sometimes in India also it is difficult to get hold of them. So what happens in such cases? Till the time we cannot produce them before the courts, trials would not be conducted. Now what the law says is that, see, if a person decides to evade trial, he does that at his own peril. Okay? You would not be able to defend yourselves, the trial would still proceed in absentia, because there has to be a finality to litigation, there has to be a finality to criminal justice proceedings also. The victim also needs some kind of a closure, the state also needs to move on to other cases. So that is why we cannot just spend years after one particular case. We have prescribed strict timelines, and In order to adhere to those timelines, we will adhere to technology. We will utilize all the technological advancements to conduct trials, whether it is through video conferencing, inquiries, proceedings. They can all be conducted electronically, and even in absentia trials can be conducted now. See, ordinarily what would happen when an accused is to be presented before the court in person? Sometimes what would happen, there is no police van that is available, there is, or maybe the van which is ferrying prisoners from the prison to the court, that is already full. Sometimes what would happen, we do not have adequate number of personnel who could escort the prisoner. So in such cases it would become a very, very difficult task. But we cannot even compromise on the safety of the accused person, and that is why it has to be ensured that there is a judicial monitoring, that the accused, whenever is required, whenever he is in custody and whenever he is required to be present before the courts, he should be present before the courts. So now what we can do, we can utilize video conferencing. So the judge can be assured that the victim or that the accused who is in custody is not being subjected to any kind of an abuse or torture. So all that can be now ascertained with the appropriate utilization of technology in criminal trials. Next would be utilization of forensics. That is mandated for offences which are punishable with imprisonment of 7 years and above. See, now as I told you, the state is very serious about improving the rate of conviction, and towards that end we have to improve the quality of our evidence, and that is why now forensic is to be invoked, forensic science is to be invoked in all offences which are serious in nature, heinous in nature, which are punishable with imprisonment of 7 years and more. Now moving on further, let us see what all has changed more, and this is now coming to the Indian Evidence Act. In the Indian Evidence Act 1872, now we have replaced it with Bhartiya Sakshya Adhiniyam of 2023. So why did we need to change this law? See, not much has changed in the evidence law in the sense 2 new sections have been introduced, 6 new subsections have been introduced, 6 old sections have been deleted, and there are multiple minor changes that have been introduced. And why did we need to do so? Because one, the Evidence Act, which was enacted in 1872 and now is the year 2023. So much of advancements in science and technology in the manner that we can collect evidence, all that has changed considerably. So how can we keep sticking to the old law, which is inadequate to deal with modern types of crimes? The existing law, the Indian Evidence Act, it does not address the technological advancements, and therefore what is required is a new law which can fulfill, which can live up to the contemporary needs and contemporary aspirations of our people. So evidence, it includes any information that is given electronically which would permit appearance of witnesses, accused, expert and victims through electronic means. Then electronic or digital records would be admissible as evidence, having the same legal effect, having the same validity and the same level of enforceability as any other document. So the Bhartiya Sakshya Adhiniyam has expanded the scope of secondary evidence to now include copies that are made from the original by virtue of mechanical processes too. The Bhartiya Sakshya Adhiniyam, it puts a limit on facts that are admissible and its certification as such in the courts. It introduces more precise and uniform rules of practice of courts in dealing with facts and circumstances of case by means of evidence. So, after discussing the main points of all the 3 new laws so far, now let us talk about the scheme and chapterization of the 3 new laws. First, we will talk about Bhartiya Nyaya Sanhita. We all know that this law has been restructured and reorganized. Earlier there were 511 sections, but now we have reduced the number of sections considerably. In chapter number 1, this law deals with the title, application, definitions and explanations. So, chapter number 1 is spread over from section 1 to 3 and it deals with the application, all the definitions and explanations which were earlier covered from section 1 to section 52 of the IPC. Now, they have been covered in only 3 sections in the new Bhartiya Nyaya Sanhita. Chapter 2 deals with punishments, which is given from sections 4 to section 13. General exceptions are given in chapter 3 that range from section 14 to section 44. Chapter 4 deals with inchoate crimes of abetment, criminal conspiracy and attempt, ranging from sections 45 to section 62. Chapter 5 is a new chapter which deals with offences against women and child. See, earlier we had section 354 which dealt with molestation, 509 which dealt with eve teasing, then we had voyeurism, stalking, then we had the offence of miscarriage and offences against children, trafficking section 312 to section 318, then trafficking section 370, rape section 375. So, all these crimes, they were spread across the length and breadth of IPC. Dowry death 304B, cruelty against a married woman 498A, bigamy 494. What we have done? All those offences, they have been taken together, clubbed together, placed in one single chapter and the title has been given Offences Against Woman and Child from section 63 to section 99. And there are multiple subparts like sexual offences, thereafter we move on to offences against marriage, then we deal with offences of causing miscarriage. Chapter number 6, which is from section 100 to section 146, that deal with offences affecting the human body. Now, there have been multiple changes in this chapter also, in the sense that many new kinds of crimes have been introduced, such as organized crime, petty organized crime and terrorist act, etc. So, in offences affecting human body, the parts are offences affecting life, the offence of hurt, the offence of criminal force and assault, kidnapping, abduction, slavery and forced labour. In chapter 7, titled Offences Against the State, it ranges from section 147 to section 158. In this, the offence of sedition, section 124 earlier, now it has been changed to treason and now it is no longer a strict liability offence under the new law. Chapter 8 deals with offences relating to Army, Navy and Air Force, ranging from section 159 to 168. Chapter 9 deals with offences relating to elections, ranging from section 169 to section 177. Chapter 10 deals with offences relating to coin, currency notes, bank notes and government stamps. These range from section 178 to section 188. Chapter 11 deals with offences against public tranquility. This ranges from section 189 to section 197. Chapter 12 deals with offences by or relating to public servants and this is from section 198 to section 205. Chapter 13 is contempt of lawful authority of public servants from section 206 to section 226. Then chapter 14, false evidence and offences against public justice ranging from 227 to section 269. Chapter 15 covers offences affecting public health, safety, convenience, decency and morals. This is from section 270 to section 297. Chapter 16, offences related to religion from sections 298 to section 302. Chapter 17, offences against property, 303 to section 334. Chapter 18, offences relating to documents and property marks from section 335 to 350. Chapter 19, criminal intimidation, insult, annoyance, defamation, section 351 to 357, and finally chapter 20, repeal and savings, is a single section which is section 358. So, from 511 to 358 we have squeezed the sections, 20 chapters, 358 sections. That is all about the new Bhartiya Nyaya Sanhita, the scheme and organization of the Bhartiya Nyaya Sanhita. Now coming to the chapterization of Bhartiya Nagarik Suraksha Sanhita 2023. Chapter 1 is the preliminary one, which deals with definitions and all. See, for the first time we have defined what constitutes bail, what constitutes bail bond. There have been changes in a number of terminology, like we don't use the term pleader, we use the term advocate. So, all this has changed, and all this is given under the preliminary definitions ranging from section 1 to section 5. Second is Constitution of Criminal Courts and Offices, that is from section 6 to section 20. Power of courts have been outlined in chapter 3 from section 21 to section 29. Then the powers of superior officers of police, aid to magistrates and the police, that is given under section 30 to 34 under chapter 4. Chapter 5 deals with law relating to arrest of persons. This is from section 35 to section 62. Chapter 6 lays down the processes to compel appearance. Here we are talking about summons, warrants. So, this is from section 63 to section 93. Chapter 7, process to compel the production of things, section 94 to section 110. In chapter 8, we deal with reciprocal arrangements for assistance in certain matters and procedure for attachment and forfeiture of property. This is covered under sections 111 to section 124. Chapter 9 deals with security for keeping the peace and good behavior. This is covered from section 125 to section 143. Chapter 10 deals with order for maintenance of wives, children and parents from section 144 to section 147. Chapter 11 is related to maintenance of public order and tranquility from section 148 to section 167. Preventive action of the police has been covered from section 168 to 172 under chapter 12, and information to police and their powers to investigate are in chapter 13, ranging from section 173 to section 196. Jurisdiction of criminal courts and inquiries and trials, that has been given under chapter 14, ranging from section 197 to 209, and the conditions requisite for initiation of proceedings have been laid down from sections 210 to section 222 under chapter 15. Under chapter 16, we deal with complaints to magistrates. This is covered from section 223 to section 226. Commencement of proceedings before magistrates is covered under chapter 17 from section 227 to 233. Charge under chapter 18, section 234 to section 247. Trial before a court of session, section 248 to section 260 under chapter 19. Chapter 20 deals with trial of warrant cases by magistrates from section 261 to section 273. Trial of summons cases by magistrate is covered under chapter 21 from section 274 to 282. Summary trials under chapter 22, sections are section 283 to section 288. From 289 to 300 is given the concept of plea bargaining. Chapter is chapter 23. Provisions related to attendance of persons confined or detained in prisons is given under chapter 24, which is under section 301 to 306. Chapter 25 deals with evidence in inquiries and trials, and this ranges from section 307 to section 336. Then other general provisions as to inquiries and trials are there in chapter 26 from section 337 to 366. Provisions as to accused persons of unsound mind they are given in section 367 to section 378, and the chapter is chapter 27. Provisions as to offences affecting the administration of justice are given under chapter 28, ranging from section 379 to 391. 392 to 406 relates to judgments, chapter 29. Chapter 30 is submission of death sentence for confirmation. Sections are 407 to 412. Appeals are in chapter 31. Reference and revision in chapter 32. Transfer of criminal cases in chapter 33. Execution, suspension, remission and commutation of sentences under chapter 34. 35 deals with bail and bonds. 36 disposal of property. 37 irregular proceedings. 38 limitation for taking cognizance of certain offences. 39 is miscellaneous. Additionally, we have two schedules. First schedule deals with classification of offences and second schedule consists of 58 forms. Now, the chapterization of Bhartiya Sakshya Adhiniyam 2023. First chapter deals with preliminary sections, which are the definitions. Relevancy of facts is in chapter 2. Facts which need not be proved are in chapter 3. Oral evidence, chapter 4. Documentary evidence, chapter 5. Exclusion of oral evidence by documentary evidence, chapter 6. Burden of proof, chapter 7. Estoppel, chapter 8. Witnesses, chapter 9. Examination of witnesses, chapter 10. Improper admission, rejection of evidence, chapter 11. Repeal and savings, chapter 12. So, viewers, in today's chapter, I tried to give you an overview of the scheme and chapterization of the 3 new laws, and also what are the main points and what are the new changes that we have sought to usher in by bringing in force the 3 new laws. That is the Bhartiya Nyaya Sanhita, Bhartiya Nagarik Suraksha Sanhita and the Bhartiya Sakshya Adhiniyam. I hope you enjoyed this lecture. In the next lecture, we will be talking about the kinds of punishments and how the concept of punishment has changed under the new criminal laws. Thank you.